Chapter 8 makes the promoter a criminal, if he violates RERA Act. Section 59-1. If Section 3 is violated, that is if the promoter starts marketing his project, without registering that in RERA, the penalty is 10% of the project cost, which will generally run in lakhs. Section 59-2. If still the violation continues for the second time, or the promoter violates any orders issued in Section 59-1, then the jail term fixed is maximum of 3 years and the penalty is doubled up by adding another 10%, which makes it 20% of the project cost. Section 60 is about violating Section 4. When a promoter provides false information while applying under Section 4 to register his project, or violates any order or direction of the RERA body, then the penalty fixed is maximum of 5% FO the project cost. Section 61 is about violating all other sections apart from 3 and 4. If promoter violates any of the remaining sections, then the penalty is 5% of the project cost, as fixed by the RERA body. Section 62 is about a real estate agent violating or defaulting Section 9 or 10 of this Act. Then the penalty is Rs 10,000 a day, for every day the agent continues his violation or default. The maximum penalty is 5% of the cost of plot or apartment or building being brokered by the agent. Most real estate agents that I know wear fake gold ornaments and generally hold litigated properties without a sale deed. It's a challenge to recover such penalties from agents. Section 63. If promoter defaults or violates any orders or directions of RERA authority, the penalty is calculated on a daily basis and the maximum is 5% of project cost. Section 64. If promoter defaults or violates any orders or directions of appellate tribunal, the penalty is calculated on a daily basis and the maximum is 5% of project cost and promoter could also be jailed up to a maximum of 3 years. Section 65. If real estate agent defaults or violates any orders or directions of RERA authority, the penalty is calculated on a daily basis and the maximum is 5% of plot, apartment, or building brokered by him. Section 66. If real estate agent defaults or violates any orders or directions of appellate tribunal, the penalty is calculated on a daily basis and the maximum is 10% of plot, apartment, or building brokered by him and he can be jailed for a maximum period of 1 year. My personal view is an allotee is a beneficiary of this law, and how can this law be used to make a criminal out of an allotee? Anyway, the general criminal laws still bind an allotee, so I feel this law should not fix any new crimes on an allotee. Section 67. If allotee defaults or violates any orders or directions of RERA authority, the penalty is calculated on a daily basis and the maximum is 5% of plot, apartment, or building booked by him. Section 68. If real estate agent defaults or violates any orders or directions of appellate tribunal, the penalty is calculated on a daily basis and the maximum is 10% of plot, apartment, or building booked by him and he can also be jailed for a maximum period of 1 year. My view is all the criminal penalties fixed under RERA can only frighten a decent man, but average criminals instantly commit crimes that lead to more than 5 to 7 years imprisonment. Section 80. A criminal court cannot directly take cognizance of an offence under the RERA Act. It's illogical, but the criminal court has to get a written complaint from the RERA authority, before it starts a criminal proceeding under this Act. This process can be manipulated by promoters to escape or delay or bury their crimes. Section 80-2. Only a judicial magistrate of first class or a metropolitan magistrate can try any offense in this Act. So if any crime happens in a remote village, the distance to be traveled will itself frustrate an honest litigant. Section 69-1. In case a company, partnership, society, or association is the promoter of a project, then who will be liable to pay the penalty and go to jail for crimes under this Act? Just like in other laws, for crimes committed by a company, every person was in charge or responsible to the company for doing its business, and the company itself will be guilty of the offense and they shall be charged and prosecuted in the court. The proviso to Section 69-1 says that any person charged in this section can be discharged free of crime, if he proves that he had no knowledge of the crime or if he proves that he did everything possible to stop the crime. Section 69-2 goes one step further. If it is proved that the director, secretary, partner, manager, or any other officer of company, society, firm or association had given consent for the crime, or connived for the crime, or were negligent about this crime, then they can be charged and pulled in this criminal proceedings. But as we know, most of the directors and higher officials never leave any footprints or handwritten documents about their activities or verbal directions. These guys quickly become close to any investigating officer. All criminal proceedings can be compounded or compromised between the parties by paying any sums below the maximum prescribed under this Act.